Good morning again. Uh, I just want to state for the record that on the evening through early morning of August 29th August 30th through August 31st, I composed numerous outlines as two actually major outlines as follow ups to long standing efforts I have engaged around the judicial branch of government in order to seek redress for not only violations of my rights to due process, but in considerations of alterations to law that have been unconstitutional in the state of Texas, as well as how it factors into a question I posed up to and including the level of the Supreme Court of the United States in 2017 regarding under what authority is what appears as a or presents as a pattern of racketeering activity evident in the federal budget process, and in consideration of under what authority, whether it comes from the behest of Congress or policy set by the President of the United States, what is redress for the unfolding of that policy. This necessarily considers the difference in the distinction between what could be considered a part of an outlay process or some kind of proprietary or specific kind of process regarding accounting, including accounting for things as economic events, versus racketeering by the letter of the law. And I contend that their burden of proof that it is, in fact, legitimate, constitutionally sound budgeting has not been met, either in the state of Texas or in the federal level. And as a matter of fact, unfortunately, recurrently, the burden of proof that it is actually compliant with the law consistently is unmet, while there is demonstrable evidence that not only is there, in fact, a pattern of racketeering, but that this pattern is willfully and intentionally engaged, including as an act of political reprisal. And not only has it been engaged in matters that at various times are selectively engaged as acts of political reprisal, but they have actually institutionalized political reprisal as part of a kickback scheme specifically for the retirement system in the state of Texas, but also in an overall scheme associated with what I understand legally constitutes acts of pension fraud that go all the way up to and through the federal government, up to and including the legislative authority for authorizing compensation and benefits for federal workers to start, but also in consideration of changes that were made legislatively to the pension systems and benefits for not only members of Congress, but also members of the State Department through the Central Intelligence Agency, as well as all the way up to the President of the United States himself. And in the meantime, as is evident not only in the state of Texas, by the way, but also in the state of Florida, there have been changes to law that have masqueraded as if they're constitutional changes to law specifically concerning the retirement system and using the retirement system in illegal manners. And in the case of Texas recently, there was a law passed specific to accessing the annuities of members of the military that are the specific charges that were originally levied in 2017 in consideration of acts of pension fraud that were also themselves acts evidentiary of other acts of securities fraud that were being engaged in connection with schemes to defraud and other illegal activities happening primarily in Houston, but also that were evident in the state of Texas and that also ended up appearing in the federal budget process for calendar or for fiscal year 2018 through the 2017 budget appropriations process. So I have an outline specifically about following up on that from a legal perspective based upon work I've already done and have maintained and consistently applied in relation to that. It also speaks to a variety of matters that have been evidentiary of specific crime intentionally engaged during this time frame. I also have another outline that I have modified from before concerning an argument that is based on both the Second and the 13th Amendment. That was a response to an original petition I submitted to the Supreme Court of the United States on January 16th, 2020, in regards to a bill that had been passed via voice without any dissent recorded through the United States Senate and then referred to the House of Representatives. To this time, the House of Representatives has not voted on that bill, but I contend, comparably to other processes, that the elements of that proposed legislation have been incorporated and inculcated into other processes up to and including what has been representing itself as the budget process throughout the year 2020 and is consistently applied throughout 2021 and what is alleging itself to be part of the federal budget process. That specific bill revealed a process whereby the mineral rights and the other sort of private property and assets of the people of the United States were allowed to be illegally acquired through the federal government and have been made available in manners that violate both the 13th Amendment, but in consideration of specific changes that have occurred, including changes that have occurred to policy in association with cases that have been allowed to go before the Supreme Court in the last year, including two that have happened just in the year 2021 itself. That this reveals that there was, in fact, an intent to illegally access the private property of American citizens and people within the United States in order to make it available for what constitutes violations to the 13th and 14th Amendments, specifically the 13th Amendment in consideration of Second Amendment claims that go all the way back to the founding of this country. Those things were available before 6 a.m. on August 31st of 2021. I have not said anything about them, and I have not moved on them, and I have not posted them publicly or even put them in an electronic record that would be accessible via the internet. I am keeping them in my files until the time is appropriate for me to move forward on them. And insofar as there may have been some indication that at this point in time that there is an effort to revisit some of the mischaracterizations of my good faith efforts to try to engage the judicial process in pursuit of my rights to due process, and also understanding myself as somebody that had an urge as well as a requirement to respond to acts of overt sabotage that I have been witness to in the last several years. It is available. And at this time, it is pending a notification that other matters that needed to be addressed at this time to show the authority of those that thus far have taken it upon themselves to remove me from the position of the plaintiff or as the petitioner and put me in the respondent role, or rather the role as the defendant to false charges. I'm letting you know I've maintained my consistency, and if you thought you were, for whatever reason, justified in trying to challenge my claim to having the authority to move forward, then now you understand what has not been moved forward on authoritatively while you've been refusing to do the role you've been denying me.